Okay, so good afternoon. We're now going to discuss on the second part of our subject, no, which is the labor relations. Okay, so we're done with labor standards already, and uh, we'll now discuss the labor relations until the final exam, no. Okay, so what is labor relations? It is the relationship between management, which or the employer, and labor, which is the employee, especially with respect to the maintenance of agreements, collective bargaining, and etc. Labor relations ensures that employee rights are protected and that local laws and regulations are applied to all employees. It also involves employee grievances and investigates relevant incidents. In other words, if there are disputes or complaints from the employees, there should be a grievance machinery, or there should be a method, no, or process on how you handle those labor disputes. Okay. So the employer is a person or institution that hires employees or workers. So employers offer wages or a salary to the workers in exchange for the workers' work or labor. While the employee is an individual who was hired by an employer to do a specific job. So the employee is hired by the employee after an application and interview process results in his or her selection as an employee. Okay. So during the recruitment and selection process, you're still not an employee there, but you will now become an employee if you are, of course, accepted and you already signed the employment contract. So the employment contract governs the relationship between the employer and employee, no? So in your employment contract, there are the provisions there, or the conditions there are, I mean, stated in your employment contract, no? Okay. Now, let us know first the declaration of policy, no, under Article 217 of the Labor Code, governing the labor relations. The first one is to promote and emphasize the primacy of free collective bargaining and negotiations, including voluntary arbitration, mediation, and conciliation, as modes of settling labor or industrial disputes. Second is to promote free trade unionism as an instrument for the enhancement of democracy and the promotion of social justice and development, and to foster the free and voluntary organization of a strong and united labor movement, to promote free trade unionism as an instrument for the enhancement of democracy and the promotion of social justice and development, to provide an adequate administrative machinery for the expeditious settlement of labor or industrial disputes, to ensure a stable but dynamic and just industrial peace, and to ensure the participation of workers in decision and policy-making processes affecting their rights, duties, and welfare. So in other words, the labor relations primarily discusses policies on unionism, no, or the labor organization. However, as an HR students, I will not focus my discussion on the labor unions, no, but instead I will focus our discussion on the employment relationship, no, uh, between the employer and employee. Okay, so when it is uh, in the actual practice, unless if your company is unionized, then these things are very important for you to know, no? But as an HR student, especially if you will be assigned or you will become a specialist or an employee relations specialist, wherein where you're going to deal with the employees' concerns, disciplinary processes, their complaints, no, or the disputes if they have complaints. So I will talk about that. I would prefer to to discuss that with you, no. since that will give you an adequate or advanced information on how you do your job professionally when you start working, especially in the field of HR. Okay? But again, I will just give you basic information about labor unions, since labor relations actually discusses about those things, no? So when you say labor organization, which is also commonly known as labor union, it is an association of employees created for the purpose of collective bargaining or dealing with employers concerning terms and conditions of employment. Okay? So for those companies who are unionized, then they have this CBA, no, or collective bargaining agreement, wherein it stipulates the relationship or the conditions between the labor union and the employer. Okay, of course, the labor unions are members of the labor unions are the employees. Okay, so legitimate labor organization. This means any labor organization duly registered with DOLE and includes a branch or local thereof. No, so in other words, not labor union are authorized, no, or legal. So you will be considered as a legitimate labor organization if you are registered with DOLE. So there are conditions or requirements that you need to comply in order to become a legitimate labor organization. Okay, so I will not discuss that further, since, as I've said, I would focus on the employer-employee relationship of, uh, those topics, no? So, who are qualified to form or join a labor union? Of course, rank and file employees and supervisory employees. They cannot lump together in a single union. They should form their own separate organization. Since the reason for that is they have separate interests, no? So, in other words, for rank and file employees or ordinary workers, they can form or join a union in their own class, no? Meaning they are all rank and file employees. For supervisory, they can form, organize a union wherein their members are also all supervisory employees. Of course, managers are not allowed to form or join a union. So, collective bargaining unit refers to a group of employees who share mutual interests within a given employer unit. So, in other words, this is the uh, group of employees, no, authorized to negotiate or do collective bargaining. Who are disqualified to join a union? Of course, managerial employees, confidential employees who have access to labor relations matters, no? So, not all confidential employees are disqualified. So, only those confidential employees who have access to labor relation matters are disqualified. Employees, members of cooperatives, of course, they cannot form a union because members of cooperatives are part owners of the cooperative. Therefore, they cannot uh, negotiate on their own, no? And then also government employees, employees of government-owned or controlled corporation with original charters, and those without definite employers. I forgot to differentiate this one, but the collective bargaining agreement is actually the contract, no, between a labor union and the employer. So whatever they have agreed, it will be stipulated in that CBA. Okay. So in cases of labor disputes, so there will be grievance machinery. So the grievance machinery is a must, no, wherein it is the manner or method. Or the process wherein if there will be labor disputes, the grievance, there should be, there are members, no, of the grievance that will handle or do the, or to manage the dispute. Okay. So grievance is a dispute or controversy between an employer and the collective bargaining agent. So individual employee or group of employees arising from interpretation of implementation of the CBA or interpretation or enforcement of company personnel policies. Okay? So if an employee has dispute or controversy, then the grievance committee will be the one to handle based on the CBA, no? Strike is any temporary stoppage of work by the concerted action of employees because of a labor dispute. So, to be considered as a strike, the stoppage of work must be concerted, temporary, and must arise from a labor dispute. So, strike should, before the labor union could do a strike, there are certain conditions that they need to follow, no, or comply first. So, they cannot directly do it or perform a strike, no. So, again, you need to comply all those requirements. So again, strike is the stoppage of work by the concerted action of employees. So what are the legal grounds for declaring a strike? So there should be a collective bargaining deadlock. Deadlock means a situation, typically one involving opposing parties in which no progress can be made. So in other words, there is negotiation and there's deadlock. So in other words, there are no, they haven't agreed, no? So there are conflicting interests and they were not able to agree agree on something. So there's a deadlock. And of course, unfair labor practices or ULP. So you may read the labor code on what are those uh, unfair labor practices, no? But again, I will no longer discuss what are those ULP involves. So lockout, it is the temporary refusal of an employer to furnish work to union members because of a labor dispute. So the other one for the strike, it's from the employees, no? But for if the employer will temporarily suspend or refuse the workers or union members to work, it's called lockout. And the legal grounds for declaring a lockout are collective bargaining deadlock and of course ULP. Okay, so those are the things on labor organization. Okay, so again, when you say labor organization, those are unionized company, no? However, uh, to form and to join a union is an established right, no? Guaranteed right by the worker. However, there are companies who are not unionized, no? For those companies who are not unionized, as long as they have proper procedures on addressing disputes or concerns of the employees, it can be it may be allowed. No, I mean it can be allowed as long. In fact, the Department of Labor of Employment encourages to have a labor management council. So it is different from labor union because labor union is needs to be registered, no, and there are certain conditions or requirements that we need to comply. However, for the labor management council, it is just a group, no, or a committee composed of management and rank and file employees, wherein uh, they will settle complaints or disputes, no. Okay. Now, as I've said, I will not focus on the labor unions or labor organizations. Now, let's proceed with termination of employment. Okay, so as an HR students, uh, part of the functions of HR is from, of course, from hiring to firing, no? So from recruitment and selection until the termination of employment. So this is very important for you to know because it will really um, help you, no, in doing your job or as a future HR practitioner. So as I'd like to emphasize the right to security of tenure, although we already discussed this uh, briefly on our previous topics. So when you say security of tenure, this simply means that the employer cannot dismiss an employee without just cause or authorized cause, no? So who are protected by the right to security of tenure? Principally, it protects employees who are holding regular employment. So managerial employees are likewise entitled to security of tenure, although they are subject to stricter norm of discipline than the rank and file employees. Okay, that is why it's very vital, no? If you're already a regular employee, then there are certain requirements that you need to follow as an HR in order to make the dismissal valid, no? Which we're going to discuss on a later part. Now, with regards to security of tenure or to the dismissal between managerial and rank and file, the rules of dismissal of managerial employees as well as penalties for their infractions are not necessarily the same as those for ordinary rank and file employees. So ordinary rank and file employees may be dismissed for loss of trust and confidence upon proof of involvement in the offense in question. But when it comes to managerial employees, the mere existence of some basis or a reasonable ground to believe that they are responsible for the misconduct will suffice for their dismissal. So in other words, for rank and file employees, for example, no, if you're a cashier, so that job involves trust and confidence, no? Now, if the cashier steal from the company or stole from a company, a proof of involvement is necessary, no, to justify the dismissal. Okay. However, if you're a managerial employee, the only proof there is, or important there is the mere existence of or a belief that you are responsible with the such misconduct, no? So that is already sufficient for your dismissal. Okay? Okay, like for example, example for dismissal due to loss of trust and confidence. Like for example, conflict of interest, wherein you were for the example, you accept gifts, no, from your supplier, and accepting gifts will result to what? Uh, you are now you are no longer impartial, no, in making decisions. Like for example, if you have several suppliers, and since you accepted a gift for example, yeah, a gift from this certain supplier, then most probably you in the later future you will favor those this particular supplier, no? So there is already uh, conflict in making decisions later on. So if your employer find out that you are doing that, then you can be dismissed because of loss of trust and confidence, because your employer doesn't trust you anymore, no? And they already lost their confidence with you. So with that, mere existence of our basis or a reasonable ground for the belief that that you are responsible for such misconduct is already sufficient, no, for you to be dismissed. Unlike again ordinary rank and file, there should be a proof or evidence, no, of involvement. Constructive dismissal is an involuntary resignation brought about by the harsh, hostile, and unfavorable conditions set by the employer. So it is an act amounting to dismissal but made to appear as if it were not. So it is a dismissal in disguise. So in constructive dismissal, the employee stops working because continued employment is no longer feasible under the circumstances. Like for example, in the case of sexual harassment, no? So if your superior is harassing you, then the employee can actually resign immediately, no? Or do not report immediately, and that constitute constructive dismissal. So the employee can stop working because of that circumstance. Now let's discuss about just and valid causes of termination. Again, there are only two reasons or causes, no, for the employee to be terminated legally, no. One is due to just causes and of course authorized causes. So when you say just and authorized causes, those are substantive due process, no? Then we also have this procedural due process, but we'll discuss that on the later part. Okay, so what are those just and valid causes? But before that, let's define first what is a substantive due process. So the substantive due process mandates that an employee can only be dismissed based on just or authorized causes, no? So these are the different just causes based on Article 300. I don't know, sorry. These are circumstances based on Article 300 wherein the employee can terminate his employment, no? So termination by employee. If there is a serious insult by the employer or his representative on the honor and person of the employee, inhuman and unbearable treatment accorded to the employee by the employer or his representative, commission of a crime or offense by the employer or his representative against the employer or any of the immediate members of his family, and other causes analogous to any of the foregoing. So in other words, the employee can terminate himself or herself due to these reasons. Okay. Now, a 1 month requirement or advance notice is required, no? If the employee I know, sorry. 1 month notice, you already know that you should render 30-day notice, no, or a 1 month notice before you will be able to resign. However, for those circumstances under this, wherein the employee can terminate his or her employment on these particular instances, the 1 month advance notice is no longer required. Okay, so I repeat, it is no longer required, not required. If an employee involuntarily resigns because continued employment has become unbearable for him, so he is not required to give 1 month advance notice. The employee can leave his employment immediately for obvious reasons. So the relief that the employee can have is, of course, reinstatement is not a proper relief, no? But separation pay, with or without back wages, would be the appropriate relief so the employee can be spared the agony to work under antipathy and antagonism. So reinstatement is actually the situation wherein an employee will be asked to report uh, back to work, no? So that's reinstatement. However, in this particular circumstance that the employee involuntarily resigned because of those unfavorable circumstances, the relief that the employee will have is a separation pay. Okay, so in other words, the employee will be paid will be paid a separation pay if the employee involuntarily resigned. What about illegal dismissal? It is a situation where an employee was dismissed without just cause or authorized cause, or where the dismissal is too harsh a penalty, such as not commensurate to the offense committed. Okay, so in other words, the employee was terminated uh, for light offenses, for example, or not a valid cause, so that will be considered illegal dismissal. Okay, like for example, if the employee goes on absent because for an emergency reason, and that's the first time the employee was absent, and when he returned back to work, he was terminated. So that can be considered illegal dismissal. In other words, the penalty of termination does not uh, commensurate, no, to the offense committed. So what is the remedy for illegal dismissal? So if you will be dismissed illegally, the only recourse available to an employee illegally dismissed is to file a complaint for illegal dismissal with the labor arbiter at the NLRC or the National Labor Relations Commission. Okay, so with that, if you are illegally dismissed, you can go to NLRC, to a labor arbiter, and file an illegal dismissal case. No, so actually they have a form there, a standard form, wherein all you need to do is fill out. No, so you will just write all those. Uh, uh, I mean your concerns and what are those benefits that you are going to claim. So you just check it. I mean, fill that out. There is also a prescriptive period, no, for illegal dismissal. So the complaints for illegal dismissal should be filed within 4 years from the date of dismissal. In other words, you should file for an illegal dismissal within 4 years from the date of the effectivity of your dismissal. Okay? So in other words, if you were dismissed on January 15, 2000, so January 15, 2005, your case is already prescribed. So you can no longer file for that, no, because it already exceeded 4 years. So the limitation there, prescriptive, meaning the limitation period, no, should be filed within 4 years. And what are the reliefs for illegal dismissal? You can be reinstated without loss of seniority, rights, and other privileges. So you can go back to work without losing all those seniority rights, no? And then separation pay if reinstatement is no longer possible or feasible. So like what we've discussed before, that example, if uh, you filed for illegal dismissal, no, and then it took 2 or 3 years before a final decision was made, and then when the decision there is reinstatement, wherein you will be asked to go back to work. However, the company already abolished that position or area wherein your former job, then reinstatement there is no longer feasible nor possible. So uh, with that, you can be paid separation pay. And of course, back wages, it restores the lost income. So back wages are those incomes that you are supposed to receive, no, because of that illegal dismissal. So for example, it's been 2 years when you were dismissed, and then the decision came after 2 years. So the 2 years span of time that you were illegally dismissed, and then the decision is really illegal dismissal, no, then you will be paid full back wages, if depending on the decision of the NLRC. For the relief of reinstatement refers to a restoration to a state from which one has been removed or separated. It is the return to the position from which he has removed. Okay, so again, that's reinstatement. Now, we also have this doctrine of strained relations. So with this, reinstatement should not be ordered anymore if the relationship between the parties has become so strained and ruptured as to preclude a harmonious working relationship. So in other words, if you already have, like, if you have conflicts, like in the case of uh, or problems or major conflict with your superior, and then your superior terminated your employment, and then later on, upon hearing of the case, uh, the relationship can no longer be cured, no? So in other words, there's already a strained relationship between you and your superior. So of course, reinstatement cannot be ordered. Then for the relief of back wages, it is a relief that restores the income that was lost because of unlawful dismissal. This refers to the compensation which an employee would have earned had he not been unjustly dismissed. So again, with regards to back wages, it could be full, partial, no, or no back wages at all. So again, it would depend on the decision of the labor arbiters or the judges of NLRC. Okay, so anyway, it will be written in the decision, no, if there will be back wages or not. Now, another important thing also with regards to employment relationship is, of course, for the employer, they have, if the employees have their rights, the employer also have their rights, which is their we call it management prerogatives, no? So this is the exercise of management. The exercise of management prerogatives belongs exclusively to the employer. So as owner of the business, employers are free to determine according to their own discretion and business judgment all aspects of employment, including hiring, work assignment, working methods, time, place, and manner of work, tools to be used, processes to be followed, supervision of workers, working regulations, transfer of employees, work supervision, lay of workers, discipline, dismissal, and recall of work. So in other words, whatever the decisions of the employer with regards to the methods, time and place, no, or the manner how they conduct businesses, so it's part of their management prerogative. Okay? So if they want to demote a certain employee or they want to transfer, who they hire, that's actually part of their management prerogative. Now, NLRC and the labor arbiter has the power to inquire on whether the exercise of managerial prerogative was tainted with bad faith or grave abuse of discretion. So in other words, although the employer has the right to manage, I mean, they have their right to exercise management prerogative, it is still subject to the review of the NLRC and labor arbiters. Like for example, if the employer claims that they are just exercising their management prerogative when they dismiss the employee, then of course the NLRC has the obligation or to review, no, or has the power to inquire whether the exercise of managerial prerogative was done in good faith, no. So only when it is established that there is bad faith or grave abuse of discretion can the NLRC or labor arbiter use their corrective powers. So if the exercise of management prerogative is exercised in good faith, then there's no problem. However, if the NLRC find that the managerial prerogative is tainted with bad faith or grave abuse of discretion, then NLRC has the right to correct such abuse or exercise. So example of management prerogative are the following. So as part of their right, I mean for the employer's right, they have the right to promote employees, transfer employees, change work schedule, to abolish department or section, to reorganize and abolish positions, to reduce personnel, to close its business, to transfer business ownership, to promulgate company policies, rules, and regulations, and to discipline employees. So these are examples of the exercise of management prerogative. So regarding those offenses that do not really fall under any of the just causes for dismissal, certain factors must be considered, such as the nature of the offense, the position of the employee, the degree of damage to the employer, the past record of the employee, length of service of the employee. In other words, if you are going to dismiss the employee not falling under the enumeration under the just causes or valid causes, then you need to take note of the following factors. No? First is the nature of the offense. So it is similarly the same with those under the valid causes or just causes. So in other words, the nature. And of course, the position of the employee, whether the employee is a rank and file or a managerial employee. The degree of damage to the employer. So if the employee committed an act relative to the employer's right, so what is the extent of damage, no? And of course, you need also to consider the past record of the employee. So if the employee already has a lot of violations, so normally it will be considered as, the totality of the employee's record, no? So if from the beginning until present, there are already a lot of infractions or violations that the employee has committed, then probably you can dismiss, no, the employee. And of course, you need also to consider the length of service of the employee. So there are cases, no, wherein the employee, whether uh, the decision is not the legal dismissal. Example, the NLC declared the dismissal as legal. However, the nature of the offense is not under the serious misconduct. Like for example, it is just disobedience or insubordination, no? And the employee already worked in this company for 20 years, so it's already a very long period, no? And the employee there was terminated due to insubordination. Okay, so sometimes they have this kind of social justice or compassionate justice, wherein they decide uh, that the dismissal is legal. However, the employer will be asked to pay separation pay, no? Uh, for the reason that uh, the employee is already, I mean, employed with the company for a long period of time. So the basis there is compassionate justice. Okay. However, if it is really a serious misconduct, then of course there will be no payment at all. No. So again, it would depend on the decision of the NLRC. Okay. So these are the just causes for dismissal. First is serious misconduct or willful disobedience by the employee or the lawful orders of his employer or representative in connection with his work, gross and habitual neglect by the employee of his duties, fraud or willful breach of the employee of the trust reposed in him by his employer or duly authorized representative. So with regards to the first cause, serious misconduct or willful disobedience, this is actually intentional, no? On the part of the employee to commit such violation or misconduct. Okay, insubordination could be willful disobedience. Gross and habitual neglect by the employee of his duties, of course. Later, we'll discuss this further. Fraud or willful breach of the employee of the trust repose, such as example is if you're a cashier, that involves trust and confidence, no? That's a position involving trust and confidence. Then next one is commission of a crime or offense by the employee against the person of his employer or any immediate member of his family or his duly authorized representative, and of course other causes analogous to the foregoing are similarly the same, no? So those are the just or valid causes of dismissal, which is part of the substantive due process, where is the first requirement, no, for an employee to be legally dismissed. Okay, so again, uh, it's very important to really assess, no, the case of the employee if the cause of the employee, I mean the termination, falls under this just causes, no, for the dismissal to be valid. Otherwise, if not within the if doesn't if not within these circumstances or causes, then probably illegal dismissal will be declare, it will be considered as illegal dismissal, no? So again, very important to take note the reason or the cause of dismissal. It should fall under this just causes, no, or valid causes of dismissal. Okay. So, and another important thing, if you are dismissing a rank and file employee, this is very crucial, wherein you must have the evidence or proof, no, of involvement. Okay, so as an HR, you are responsible to gather those documents, proof. Otherwise, you will be asked to pay, so it incur a lot of expenses. And in fact, lawsuits are very it's very expensive, no, on the part of the employer, because you need to pay the lawyers, And of course, whatever the decision, if it's unfavorable to the employer, then the employer will pay whatever the monetary claims, no? Like if the decision will be part of the decision is to pay the full back wages, the reinstatement, and all other things. So it's very costly on the part of the employer. That is why, as an HR, it would be knowledge of law is very important, no? So you should be knowledgeable about this just causes in order for you to be confident whether to dismiss an employee or not, no? Now, if you have this knowledge, if you know the laws, if you know the law, you will not be you will be confident, no? Or I mean, you are not afraid to terminate an employee, especially those employees who are really, I mean, not perform. I mean, those problem employees, no. So as long as you have uh, evidences, proof, you have the rules, company rules. It is very crucial, no, in in, 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 in in dismissing an employee. So we'll talk more about that. What are the requirements or a company should have, no, as part of your HR job? What are those things that you need to have? Like example, you should have a code of conduct, uh, enumerating all those rules and regulations of the company, which is very important because that will act as the Bible, no, between the relationship. I mean, the employees' conditions, or part of the conditions of his or her employment, wherein all the rules are being set on that code of conduct. Okay, so we'll stop here and we'll continue to discuss next meeting about just causes for dismissal. So again, if for your questions, you may send a message to our group chat or send your question to our class middle so that we can discuss that during our uh, weekly group discussion. Okay, so that ends our discussion today. So enjoy the rest of the day. Thank you.